Yesterday, Dr. Matembe appeared before Luzira Magistrates Court, where she was charged with one count of promoting sectarianism. She denied that charge and was remanded to Luzira Government Prison. On returning to court today, Matembe applied for bail, arguing that she's of advanced age, has a constitutional right to bail, and is not likely to interfere with the ongoing investigations.
Humble submission that the applicant before you being 73 years of age would squarely fall and fit in the definition of an applicant who is of advanced age owing to this authority. If I wish to avail court with the same, and Your Honor, the reason for availing court with the same is to persuade you in considering our side. You watch all that submitted and said. It's my humble conclusion for emphasis that the charges against the applicant, they are not so grave in nature. And the charge is not among those that require exceptional circumstances. As is the case normally in the cases before High Court. We thus call upon operate this honorable court to exercise its discretion judiciously taking into account the health of the applicant, the interest of justice, and above all, Your Worship, the obligation imposed on court under Article 126(1) to exercise judicial power in accordance with the people's norms and aspirations. And Your Honor, that goes along with Article 20 that calls upon no mandates court to uphold the fundamental human rights. And these are what Article 20 Clause 2 that mandates this honorable court to uphold the fundamental human rights. And these are what the applicant is laying before you. That's the right to liberty, the presumption of innocence, and her right to health. Your Honor, I would like to end my submission by praying that the applicant be granted, as may please this honorable court, bail pending trial on such reasonable conditions as this court may deem fit. I so pray.
She presented for sureties including Lucy Akero, MP for Amuru District, Naomi Kabasherirwe, MP for Lushenyi County, Prima Kwagala, and lawyer Godibatu Mushabe.
This matter was adjourned today for the hearing of the accused person's bail application. And Your Honor, we are ready to proceed with the same. Your Honor, the accused person, Dr. Miriam Matembe, a 73-year-old senior citizen, veteran politician, former Minister of Ethics and Integrity, former Member of Parliament, Constitutional Assembly delegate, and former member of Uganda Constitutional Commission. And lifelong champion of women's rights and good governance.
Are we going to read those things?
Applies.
The two first.
So, I'll give you the back.
Yeah.
Oh, sorry.
I'm a member of Uganda
Constitutional Commission.
Former member of Uganda Constitutional Commission. And a member of former member of Pan-African Parliament. And a lifelong champion of women's rights and good governance. Applies for release on bail. She's also a lawyer who enrolled as an advocate in 1979.
The doctor of laws.
And holds a doctorate of laws.
1979.
1979. Your Honor, our application will have 2 legs. But for emphasis, the person I've described applies for release on her own recognizance. So, Your Honor, she makes this choice. This choice in itself underscores her commitment to justice, her low risk of flight,
You must go on, huh?
commitment to justice, her low risk of flight, and her respect for the rule of law. Your Honor, as court may see, even as of yesterday, she is manifestly unwell. And so she will address court substantially through counsel while reserving the right to affirm.
Well, preserving, asserting.
The right to affirm or supplement her own recognizance, since bail is a personal contract between her and the court. she did ask for that, and Your Honor, that will be, pray that court takes note, that should be allowed to supplement. So, Your Honor, there are 12 strong grounds for bail on her own.
The application was opposed by the prosecution, led by Maria Mukuruthum, who argued that advanced age alone is not sufficient ground for granting bail.
This surety, yes. Let me go by his letter. I hope the letter is okay. Let me use his national ID. He's called Godba Wilson Tumusime. They said he's a lawyer. Tumushabe? Yes. They said he's a lecturer, a lawyer. But this surety also is not truthful, Your Honor. This surety gave us a number of 07750000737. This number is also in the names of a woman. Yet he's a man here. That is why I wanted to see him. He's a man actually. But this the name is Ashemeri Agnes. You know? So how are we going to find the applicant through the sureties when the sureties are giving us wrong information? When I go to the medical report, yes, Your Honor, police form 24. The applicant has told the court that for her she's unwell. But unfortunately for her, she has not produced any old medical reports to substantiate what she was saying. I offered my police form 24 yesterday to her. And I even asked her, Madam, were you medically examined? She vehemently said, I have never been examined. In her own words, Your Honor, I'm not even putting words in her mouth. I have never been medically examined. Yet, according to me, a police form 24 is a document filled by a police sergeant who is a doctor, who has fully examined the applicant. But she stood here in her own words and claimed for her that doctor just wrote her own things. For her, she has never been examined. Now, I find it peculiar for my land friends to hold this document in high esteem and say for us, we are relying on this document, our client is unwell. Yet the client said, me, I've never been examined. Now, Your Honor, I'm in a dilemma. I don't know. Most of the times when an accused person stands up and objects to this document, the court gives an order for an independent examination. So, I don't know if my land friends have other documents to rely on, because your client vehemently denied the document in court. So, Your Honor, I feel that point of being unwell and terribly sick. I don't know how they are going to prove it. In conclusion, in conclusion, I have studied the character of the applicant, Your Honor. From the time she came to court up to now, Your Honor, when I examined her in a friendly way and her response, we fear that she may continue using words which may amount to committing offenses. And Your Honor, this is among the conditions. This is among the conditions which court has to look at carefully under the bail guidelines. The likeliness of the applicant to commit an offense while on bail. Their character has to be put in play, the way they present themselves. Are they being courteous? Are they being adamant? You know, that was my observation in court here. However, if this court is inclined to grant bail to the applicant, we humbly pray that the applicant surrenders his passport to court as one way of ensuring that she will not run away from us, because she said she's already on the run. So maybe the passport, if it is handed over to court, she may not run away. And now we also pray for an order refraining the accused or the applicant from using such words the state may consider committing a crime. At least she should refrain. I'm not saying she should not talk, but in my prayer is for her to be refrained from committing further crimes. What statements that may be taken by the state to amount to committing a crime which is as similar as this crime we have here. Thirdly, Your Honor, we pray for other reasonable terms, Your Honor, that you may consider fit. That will also ensure that the applicant comes back to court for her trial. So I pray, Your Honor.
She also argued that the presented sureties were not substantial because they are places of residence are far from the accused's home. The prosecution therefore asked court to deny the accused bail. After considering submissions from both sides, Magistrate Gloria Tim granted Matembe non-cash bail of 3 million Ugandan shillings non-cash and the first sureties each 2 million non-cash.
To interfere with investigations, that's to say, witnesses or evidence. Counsel for the applicant submitted that there was no such likelihood due to the good previous conduct and responsible nature of the highly esteemed accused. If there are indeed grounds to lead to the opposite finding, the grounds would have to be clearly stated with evidence. This is in light of the presumption of innocence. And in the case of Panju versus the Republic that was cited, it was held that in such circumstances, the investigator should have a sworn affidavit to substantiate any allegations, any such allegations. I'm inclined to grant the bail application on the following conditions. 1, the applicant is to be bound in her own recognizance of 3 million Uganda shillings, not cash. Each of the 4 sureties is also bound in the sums of 2 million.
The magistrate, however, warned Matembe against making statements that rules out in the cancellation of her bail.
3. The applicant to execute a further bond of refraining from any acts of hostility or breach of peace till the case is heard and finalized. For failure to do so would lead to cancellation of bail. The applicant will continue reporting to this court for mention pending the completion of inquiries and or during the period of hearing of the matter, as the court will from time to time communicate.
In her ruling, magistrate explained that bail was granted because the accused had presented substantial sureties and that there were no evidence that she's likely to interfere with the ongoing investigations. There was jubilation among Matembe's relatives, friends and supporters who had filled the court to capacity following the ruling. Matembe's legal team welcomed the court's ruling.
Decisions in the recent history. If this was a court of record, I would even invite judges in the High Court in political matters to stop having political lenses whenever they approach political matters. The political doctrine question has been answered in this matter. That courts should not depend on politics in making decisions, but follow the law. The judicial officer was very clear that arriving at this decision was not easy. There are threats to life, threats to job, and other factors which are extraneous to what she ought to follow as a judicial officer. In the decision today, she's been very clear that she has been guided by the law, courage, compassion, and her belief as a religious person. And that is what should guide all judicial officers in similar matters. If that was to be the case, then the reason for bail would be resolved. The purpose of bail is to ensure that a person who has been charged with an offense is presumed innocent and should not be incarcerated or detained during trial if such a person has factors like the Honorable Matembe. So the age factor played in, and her background. How do you say that a person who was a minister for ethics and integrity, how do you impeach such character like the state did? The state was saying that the Honorable Matembe's character is questionable. A person who was a minister for ethics and integrity, a person who presents God at every opportunity, a person who calls upon Christ at every opportunity. I think it was only proper for court to put the state in its own place of ensuring that the justice you come for here as a representative of the state does not isolate politics, does not isolate the Matembes. You come here in the interest of justice, and justice has been served in this matter. Kubadde gwa kusiga bukyayi. Kooti egambye nti newankubadde tennamusalira musango oba ebigambo bye byali bisiga obukyayi oba nedda. Naye ekyetegereza nti omusango ogufaanana bwe guti guba gwa byabufuzi. Mu kumanya nti ye munnabyabufuzi, kooti emutaddeko akwakwakulizo. Newankubadde guno omusango tegunnawulirwa era tunagukusingisa, guyinza okuba nga gwa byabufuzi, wali okomentinga nga munnabyabufuzi. Ne weewale mu kadde kano ng'omusango gugenda mu maaso okuddamu okwogera ebintu ebiyinza okuleetera ate okukuza wano mu mbeera efaanana bwetu, ekiyinza okuleetera okweyimirira okukola ki, okusazibwamu. Naye atwemphasizinga mu Luganda nti state attorney government no, the Honorable Miriam Matembe wa mpisa mbi, kyennyini kyekibadde eky'empisa embi. Omuntu yali minisita w'empisa. N'ekirala omuntu buli wabadde ayogera ng'ayita Katonda naye wamaze otuwa decision ayise Katonda, weyo gogamba nti wewe empisa embi. Tukubiriza nga tuvudde ku kitongole ekiramuzi, kyetukubiriza nti otuwanga decisions mu bwangu. Kooti eno nga bwekoze etuwuliriza mu lunaku lumu newa decision mu lunaku lumu, kyekigendererwa ky'okusaba okweyimirirwa. Era ekyo tukisanyukidde, tusaba ne kooti enkulu ezisinga ku eno zigoberere ekyo kubanga kyekiri mu mazima, kyekigendererwa kya constitution, ate bo bennyini abalina ogiteeka mu nkola gibatera obutagoberera.
The people, the members of the public have been behind this, the Fourth Estate, the women who have also been here in solidarity, because this is basically the only way we can get our freedom. This is the only way we can fight impunity.
And then you leave courts to process irregularities and abuses of the military. The army has no power to arrest Ugandans. The overthrow of the constitution means overthrow of executive authority. Article 99 is very clear. President Museveni derives his authority through the protection of the constitution. The constitution has been overthrown under his watch. He's now just a figurehead. He cannot claim executive authority when he cannot protect the constitution of Uganda. He's a mere figurehead in State House. I hope he will have time to address the nation, because it's just 2 months of taking oath to protect and defend the constitution. That is presidential oath. Arrests are very clear under Article 23 by police, detain in gazetted centers, inform family, relatives and lawyers where the detained person is, inform them of the crime they are accused of. Now the military abducts people, runs with them in drones, throws them in the basement. There is no executive authority in Uganda. It has been overthrown. It's a very big shame. For Miriam Matembe, she's one of the surviving matriarchs of the women movement. Yep. This has been demonstrated by women camping at this court from morning up to now. Women have very many obligations, care obligations in their families, care obligations plus work obligations. But they've sacrificed all. Women of all generations, they've camped here. This is an embarrassment to President Museveni's government, and it's a big shame. Mukyala w'ekitiibwa kya Miriam Matembe, amagye gamuwamba ne gamusuula mu basement ne gamugjayo ennaku bbiri nga ziwedde ne gamudampinga ku poliisi. Era poliisi efuuse clearing house ya military detentions. Tekyalina buyinza ssemateeka bwegiwa. Kiswaza nnyo nti omukyala eyamenyeka omugongo ng'akola ssemateeka wa Uganda gwe bakutte ne bawamba ab'amagye nga batyobola ssemateeka w'eggwanga. Era akawairo akachenda mwenda musemateeka kagamba nti President ekitiibwa kye n'obuyinza bwe abijja mu kukuuma ssemateeka. Amezi 2 gaakagwa ng'amaze okulayira bupya akute ssemateeka mu ngalo agiraga ensi yonna nti agenda gikuuma. Naye y'omu katafuuse ekifaanani mu ntebe kubanga alemerwa okukuuma ssemateeka wa Uganda. Era constitution eri clear nti presidential authority eva mu kukuuma ssemateeka. President kati yeefudde ekifaanani nga batyoboola ssemateeka wa Uganda era takyalina kukireminga nti alina presidential authority kubanga eyo authority eva mu kukuuma ssemateeka n'okulaba nti abantu bonna bakola nabo mu gavumenti bateeka mu ssemateeka ekitiibwa. Kati takyalina ekyo ekitiibwa ssemateeka kye yamuwa kubanga yeefudde ekifaanani mu ofiisi.
Thank you. Court will resume on 19th August 2026 for mention of the case. The offence of promoting sectarianism carries a maximum sentence of 5 years imprisonment upon conviction.